You asked for it, you got it. You want to know all about pistol braces, the proposed regulations by the ATF, the possibility of amnesty, and what all this means? Where does all this come from? Is there legal authority to even do this? Well, we have got the man for you. We're bringing on, in just a minute, Stephen Halbrook, one of the few attorneys that has defeated the Department of Justice and the ATF before the United States Supreme Court on multiple occasions, by the way. And he is going to come here and lay out the details of how all this works. Why is he the man? For many reasons, including the fact that he writes the definitive book on firearms law in the United States that's cited by many federal courts, and Stephen himself has been cited by the United States Supreme Court on many gun cases, including a case you may have heard of. Oh, that would be called Heller versus the District of Columbia on the Second Amendment. Stay tuned for a very special interview on pistol braces, ATF regulations with Stephen Halbrook, constitutional scholar, Second Amendment attorney, and member of the U.S. Supreme Court Bar. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, member of the United States Supreme Court Bar, best-selling author, and proud American gun owner. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. And please follow us on Twitter. Yes, we are now on Twitter as well. So I'm very excited here to be with Stephen Halbrook, who I think it's fair to say may be the most important person outside of the Supreme Court itself when it comes to the text, history, and tradition and understanding of the Second Amendment's right to keep and bear arms and the American history associated with all aspects of it, going all the way back to jolly old England, centuries before even the birth of William Shakespeare. Stephen, to say the least, may be the most important person when it comes to dealing with issues involving the ATF. He has no fewer than 3 major victories before the United States Supreme Court as the lead lawyer and the oral advocate on behalf of issues against the United States government, and he's managed to win 3 of them, one of which actually is going to be highly relevant going forward to some of these sort of Joe Biden-related ATF-style regulations where they're trying to change the law through regulations and not statutes. In that case, is Thompson Center Firearms, which, of course, Stephen is going to talk a lot about here today. But Stephen's record goes on and on and on. If you want to know all of it about it, go to StephenHalbrook.com. You can see all of his credentials. It'll take you days to read them all. He has multiple books on the Second Amendment, including the most recent one, The Right to Bear Arms, which I'm sure was highly influential to the U.S. Supreme Court in the recent Nyserpa versus Bruin case. Stephen Halbrook's scholarship in history has been cited repeatedly by federal courts, including the United States Supreme Court in the Heller decision, for example. And beyond that, in addition to all of his different books, including Gun Control in the Third Reich, he also has countless law review articles, and his history books really do make a huge difference in protecting our right to keep and bear arms. So we're very excited to have Stephen here. So Stephen, welcome aboard to the Four Boxes Diner.
Thank you, Mark. Glad to be on the show. That was quite a generous introduction.
So before we get into the details, I just want you to talk briefly about the 3 Supreme Court victories you had all against the United States government, including this Thompson Firearms case, which seems to be highly relevant to issues associated with the NFA and the ATF's effort to make up new laws.
Well, Thompson Center Arms versus United States was decided by the Supreme Court in 1992. And it had to do with what was called the contender pistol and contender carbine kit. It was a single-shot pistol. You could get a long barrel and a shoulder stock with it, and you could take the receiver, the frame or receiver, off of the pistol and assemble a long-barreled rifle. And there were warnings not to assemble it as a short-barrel rifle. The government took the position that, well, if you could assemble it as a short barrel rifle, it was one, which is like saying, since you could murder somebody with a firearm, then you did murder someone with a firearm. We went all the way to the Supreme Court, and in a 5-4 decision, we won that case based on the fact that the long barrel with the shoulder stock made the firearm legitimate as a non-National Firearms Act firearm, and so it was held not to be an NFA firearm, and the court appealed to the rule of lenity, meaning that if there's an ambiguity in a criminal statute, you interpret it against the government and in favor of the person to whom it might apply. So that was the Thompson Center Arms case, and the reason it's relevant to these other issues like pistol braces and frame or receiver and all of that is that the government doesn't get the benefit of the doubt. It cannot make up new regulations that essentially make up new criminal laws. And if there's any doubt about it, the law is construed against the government.
You know, I want to start off, Stephen, about these stabilizing braces, and I think it's very important. There's a lot of information out there, and that's why I wanted to bring you onto the show, because I know you know really what's going on here and really understand this better than anybody else, because you're the only person on YouTube or beyond that has argued these kinds of things before the U.S. Supreme Court and won against the ATF and the Department of Justice. So let's talk about these stabilizing braces, these pistol braces, and the related amnesty. This is a super hot topic. Let's just start out with first principles, the most basics. So the major federal law we're dealing with, setting aside the Constitution, is the National Firearms Act. Can you tell us what is the National Firearms Act? And then we're going to take it from there and break it down in detail as to how it applies to these pistol braces. So what exactly is the National Firearms Act, and why should people care about it when it comes to pistol braces?
Well, the NFA, National Firearms Act, passed in 1934. It was revised in 1968 and a little bit more in 1986. That is a tax and registration system Congress passed purportedly through its tax power. They can require registration to keep up with who has paid the tax. There's a $200 tax on making or transfer of most NFA firearms. And if you have an unregistered NFA firearm, that's a felony. You can get 10 years incarceration. So it's really something very serious for gun owners. Now, the one of the firearms under the NFA, and by the way, they're narrowly defined. Normal firearms are not under the NFA. Your normal shotgun, rifle, or pistol. But if it's a rifle with a barrel under 16 inches, then it is defined as an NFA firearm, and it has to be registered. That goes to what is the definition of rifle? A rifle is a weapon that is made, designed and intended to be fired from the shoulder, and that fires a single shot through a rifled bore. And so the whole issue involving the pistol braces are they really intended to be fired from the shoulder? Now, ATF took the position for years that a pistol brace was a device that it originally approved to be used by handicapped people. And so the idea was you could have your pistol, and then there would be a brace coming out, and you might have a Velcro piece that would help hold it on your arm if you didn't have the use of the left hand, for example, and you could hold the pistol out. And that's why they call it a stabilizing brace. It stabilizes it for firing. There came a time, really, I guess it was in 2020, ATF tried to set forth some kind of directive that some pistol braces are short barrel rifles, but it pulled back that after a few days. But now, pending before the ATF is a regulation that tries to set a criteria for what is a pistol brace versus what is a short barrel rifle. And so that's we don't know what the final regulation is going to be yet, but it's pending before ATF. When they proposed it, they had this criteria worksheet where if it got points for different things, and if it had too many points, then they would consider it a short barrel rifle. I don't know if that's going to be in the final regs, though. So we don't know where this is headed until they actually finally do it.
So let's stepping back for a second. Under the National Firearms Act, there are 5, as I understand it, Stephen, from your prior work, there are 5 different types of so-called firearms that fall under the NFA that are subject to this special tax. And jog my memory, are those 5 different weapons or firearms, so-called firearms under the NFA? I believe they're short barrel rifles, which comes into play with the pistol brace issue. Then there's short barrel shotguns. Then there's so-called silencers or suppressors. Then there's destructive devices. And of course, the last and number 5 firearm, if you will, is a machine gun or machine guns. Are those the 5 categories of NFA weapons, Stephen?
There's those, and then there's one called any other weapon. It doesn't really mean any other weapon, but when it's defined, it says any other weapon that's concealable in the person other than a pistol or revolver. and ATF interprets that to be a weapon that's overall length less than 26 inches.
I see. Now, for the purposes of the stabilizing brace debate that we're having here with the ATF, or we may be having very soon, is it the one category, short barrel rifles, that really touches fingers with stabilizing braces attached to pistols?
Yes, it is, and here's the deal. So they were designed and approved by ATF originally, as I said, to mount on your shoulder for stabilization. If you make the brace too long, you could make it into a shoulder stock, and it would be a short barrel rifle. But the problem is ATF has approved these devices as not being short barrel rifles for years now, and now they come upon, under the Biden administration, with a proposal that would bring a lot of these pistols with braces into the short barrel rifle category. And so something was okay and legal today, and then tomorrow it's going to be suddenly criminal without Congress changing the law at all.
So how do these pistol braces work? So let's, to be clear, are these being attached to, when we use the word pistols here, Stephen, in the context of the NFA, are we talking about really any kind of handgun? Could be revolvers, could be semi-autos. Are we talking about any kind of handgun where we're referring to pistols here?
It could be any kind of pistol. It could be a single shot, revolver, semi-auto, and the Gun Control Act and the National Firearms Act, they don't really define a pistol or revolver, but there's ATF regulations that do, and it's a firearm that's designed to be held with a single hand. And we all know that pistols are commonly fired not just with one hand, but with two hands, but nonetheless, despite that fact, a pistol is designed under the regulation to be fired with one hand and not mounted on the shoulder.
Okay, so the different things we're talking about right now is we're talking about a pistol, which is under the law something to be fired with one hand, even though it's often fired with two hands because people use two hands with handguns. We're dealing under the NFA, the definition of what is a short barrel rifle. And then the third sort of object we're talking about here are these pistol braces, which are really, it sounds to me, an appendage, an accessory, an extra part, if you will, that you can attach to a pistol or handgun that lengthens the handgun. So really we're talking about what exactly is the difference between a short barrel rifle that requires registration and taxation under the NFA versus a pistol with this brace, with a pistol with this brace that somehow lengthens the pistol, and now all of a sudden does that become a short barrel rifle under the NFA? Is that kind of what the issue's about, Stephen?
Yes, it is, and it goes to whether it retains its status as a pistol, meaning it's designed to be fired by the use of a single hand, or if it's a rifle, it would have to be made, designed, and intended to be fired from the shoulder. And so that's the bottom line to this. If that's the case, it's a short barrel rifle, and you don't need an ATF regulation to tell you that. It's right there in the statute.
So it's kind of interesting, Stephen. So a handgun is something that's intended to be fired with one hand or designed to be fired with one hand. And then a rifle, including a short barrel rifle, is something that, among other things, is intended to be fired from the shoulder. So the question I have, Stephen, is whose intent really counts for the law here? Is it my intent, whether or not I intend to shoot this gun from my shoulder, or am I just want to shoot it from my one hand? What intent really matters in understanding what is a pistol with a brace versus a short barrel rifle that has to be registered on the NFA? How do we figure this out?
It's really a factual issue on a case-by-case basis, and there's not an intricate definition of the terms made, designed, and intended. But if you think about made, it would suggest that you have if it's a rifle, the ability to put a shoulder stock, or actually it's assembled onto the receiver and there's a barrel on it too. And designed, that would seem to be the intent of the manufacturer. Did you make this item into a rifle like a full-fledged shoulder stock? Or is it just a brace to be used to stabilize your one-hand hold or maybe your two-hand hold? And is it intended to be fired from the shoulder? Well, since it already had the term design there, that seems to be the manufacturer's intent. So intended to be fired from the shoulder would seem to be the owner's intent. But once again, the courts haven't sorted that out in a precise way. But it's got to be considered. And if ATF was to charge and prosecute somebody with a short barrel rifle, it's really up for grabs. I mean, the jury would decide whether it was intended to be fired from the shoulder versus just held by one hand or two hands.
Now, I am a right-handed person. I am not a left-handed person. I'm do a lot more effective things with the right hand than the left hand. And I bring this up, Stephen, because I want to talk about the role of these stabilizing braces, these pistol braces, if you will, attached to handguns. Because, for example, I might be able to fire a semi-automatic pistol with my right hand without a problem. But if I have to start using my left hand, I would be much better off probably with some sort of a stabilizing brace. So there's an example where, although I don't consider myself disabled in that sense, really, if I'm trying to fire a handgun with my left hand, I effectively am disabled because I'm not very good with it. I'm not ambidextrous. So how does that work? It's intended for disabled people originally, but in the modern era, what does this even mean anymore in terms of these stabilizing braces?
Well, so that was the original intent of the designer. The manufacturer was to help handicapped veterans, and specifically, who had lost the use of one of their hands or arms. But of course, then they became very popular and were sold to the general public. And it's not really an issue of left versus right. And in fact, if you train yourself properly, you really ought to train shooting with your left hand if you're right-handed, just because you might have an injury with your right hand if you're in a confrontation. And you'll be surprised what good scores you get on a target sometimes with your left hand. But despite that, what this whole issue boils down to is the fact that we've got, I don't know how many hundreds of thousands of these pistols with stabilizing braces on the market and in the hands of consumers. And for ATF to retroactively redesignate them as short barrel rifles is nothing less than incredible that could happen without any change in the law.
Yeah, and now let's talk a little bit about changing the law. One of the big questions we often get here at the Farbox's Diner is, what is the difference between, the Constitution, the statutes, meaning federal statutes, and regulations? In particular, usually legislation is passed by Congress, and we have to do what Congress says, assuming it's constitutional. But it seems like ATF has really taken over the role of Congress when it comes to a lot of these firearm issues, and basically changes the law materially through regulations. How does all this work, Stephen? And is it appropriate? And by the way, you won that major case at Thompson Center Firearms. How does that, it seems to me that the case that you won before the Supreme Court would actually limit the ability of the ATF to act, in addition to this most recent case of West Virginia versus EPA, which also seems to have suggested that regulatory agencies cannot go off the rails when it comes to making up the law as they go.
Yeah, I mean, Congress makes the laws and the executive branch is supposed to enforce the laws. That's what they taught us in civics class in, the 8th grade or whatever. And so when Congress passed the National Firearms Act in 1934, and then Congress amended it a couple of times, for decades, ATF stuck with those definitions in its regulations. It simply copied the statute. And by the same token, in the various definitions of firearm in the NFA and also in the Gun Control Act, a separate statute, the ATF did not try to go beyond the statute. Now, of course, there were times in their history when they went beyond the statute in their enforcement policies, but in terms of the actual regulations, not so. Now, so this comes down to the fact Congress makes the laws, and when Congress defined NFA firearms, ATF should not be mucking around with the definitions and adding to those definitions. They can have a policy or a viewpoint or an opinion about what the statute means, but they should not be making a regulation and then acting like that's binding on the public. Like I said before, if you were charged with having a short barrel rifle, it would boil down to what the jury would say. Is it made, designed, and intended to be fired from the shoulder? It would not be whether there's some kind of chart that ATF made up and said was a regulation, and then that would determine whether it was a short barrel rifle.
Now, does the phrase intended to be fired from the shoulder, is that found in the NFA? So if it has to be intended to be, so now if we think the intent is from the manufacturer's point of view, and the manufacturer intends a pistol with a brace to be fired from the shoulder or not, and let's assume they do not, and they issue a statement like your client did in Thompson Center before the Supreme Court and says, look, do not fire this handgun with this brace from the shoulder. That is not the intent. Is that enough to sort of win the fight against the ATF if someone is arrested down the road for saying, hey, you have a short barrel rifle here because you have a handgun with a brace, and we define that as a short barrel rifle? How does that conflict play out?
Well, I think once again, it's going to depend on the facts. If you could have something that is, by anybody's definition, a shoulder stock, the fact that you call it a brace is not going to make it a brace. But on the other hand, the items that are on the market aren't like that. I mean, if you look at a normal rifle with a normal shoulder stock, they're not like that at all. These braces are extensions from the rear of the pistol that attach to the pistol, and they're made in a way, it could be a Velcro attachment, or it could be just a kind of a fin that goes against your inner forearm, that allows you to hold the pistol in a comfortable and stabilized way to try to make good shots. So it's really going to depend on that. And once again, ATF should not be monkeying around with definitions that Congress has passed, because that's part of the executive branch, and they're under the direction of the president. We know politics plays a role in policies that agencies implement, and so it's up to Congress again to make the law, especially the criminal laws, and not to be going out on a limb, and like in the West Virginia versus EPA case, making major decisions about things that Congress didn't say anything about.
Well, now I have read this is a very long, complicated proposed regulation that the ATF issued. I believe they issued it a few months ago, Stephen, this new pistol brace regulation. Is that correct?
It's a proposed regulation. They've not issued a final regulation.
Right. So I think that's very important for the audience to understand. So right now, ATF is contemplating regulating this further, but it's not final, which means it's not binding on anybody as of now. But as I read the proposed regulation, they're trying to create some sort of a point system where they account for a pistol brace's length, the materials it's made out of, maybe the structure, its design. Are those some of the considerations that the ATF is trying to figure out? How do we figure out when is something a stock and when is something a pistol brace, or how does that work?
Right. I mean, they look at the weight. It cannot be too light, and it cannot be too heavy. It's got restrictions on its overall length, or on the distance between the trigger and the end of the brace. So there's all this technical stuff, and it seems like it goes way beyond the simple concepts in the statute of made, designed, and intended to be fired from the shoulder. That's really a factual question, and once again, either it is or it's not, and if it's a criminal case, the jury decides that. It's not something that you go through this, what looks like a mathematical chart that's 2 pages of fine print, and it has to do with what kind of sights or not it might have on it, or if it doesn't have sights on it. There's just one thing after another that they just made up out of thin air that is just agency gobbledygook that it goes so far beyond the statute that when they do the final regulation, it might be they won't use this mathematical formula, this criteria. We don't know what they're going to do. It's still up in the air, and once again, they shouldn't be doing anything.
So, Stephen, why is the ATF doing this? Realistically, we talk a lot on this channel, for example, about the different types of crimes. And one of the things I drive home is the difference between malum prohibitum crimes, which is basically the politicians say it's a crime because we say so. I'm your father, you do it because I'm your father. That's the end of it. And that's really malum prohibitum. There's no moral component to it. There's no victim component to it, which of course is in contrast to malum in se crimes, which we just know is inherently morally wrong. Murder, rape, robbery, assault, battery, theft, fraud. That's just something we understand as humans to be wrong or immoral in some component or some way, much different than these malum prohibitum crimes, which are just because we say so. But it seems to me, Stephen, a lot of these distinctions between a handgun with a stabilizing brace versus a short barrel rifle where you can go to jail for 10 years, it seems like there's no purpose to, there's no victim here. This is malum prohibitum stuff. What the heck is the ATF trying to accomplish mucking around with all this, given these are victimless crimes. These are administrative code issues with terrible criminal penalties if you get it wrong, though. So what is going on with all this, Stephen?
To say the truth, it really goes back to failures by Congress. The National Firearms Act was passed by Congress in 1934 because of gangsterism. Well, what caused gangsterism? It was prohibition. And so we had all this violence from the Prohibition era, bootleggers, and so they say, okay, we're going to restrict these different weapons. And what they put in the bill at first, they were going to make pistols and revolvers subject to all these registration requirements. And mind you, this was in the Depression, and it was a $200 tax. So it was intended to be prohibitive. So they ended up with taking pistols and revolvers out, but they had machine guns in. They had shotguns with barrels under 18 inches. And by mistake, they put short barrel rifles in. And it has to do with the fact that it originally had pistols and revolvers or any other concealable weapon. When pistols and revolvers got taken out, it made no sense to put in rifles with barrels. It started out being under 18 inches. Now it's under 16 inches. There was a member of the House of Representatives who suggested putting that in so that rifles that were used for deer hunting would not be considered any other weapon or the concealable weapon type of firearm that was left in the NFA. So the whole thing was a mistake to even put it in. Nobody ever said short barrel rifles were gangster weapons. And think about it, if long barrel rifled arms are legal and handguns, which are rifled arms, are legal, why would you say that these intermediate size firearms that are rifled and they fire one shot per trigger pull, why would they be subject to all this restriction? And just because they got into the NFA by mistake, now you've got courts calling them gangster weapons, which is ridiculous. Their rifles are used less in crime than certainly than handguns. And so, like you said, it's a malum prohibitum type law. You could go to prison for 10 years for not doing anything to anybody. And on the other hand, you might have malicious wounding statutes where you actually shoot someone and intend to kill them, and they're only subject to 5 or 10 years. So this needs to be reformed. I don't know whether it ever will be, but it should be.
Well, you raised a great point, Stephen. And I want to talk, because some of the questions that we've gotten on the channel involve the constitutionality of some of the NFA items. But let's focus just on the short barrel rifle, because that's the one that's touching fingers with these pistols with stabilizing braces attached to them, whether they become short barrel rifles under the NFA or not. One of the questions, of course, is we know from the Supreme Court's decision in Heller, McDonald, Caetano, and now Bruin, that those firearms that are commonly used by Americans for lawful purposes, including stun guns and Caetano, of which there's only 200,000 stun guns in America, at least at the time of the 2016 decision. The question is that people have asked is, well, we're confused here. Handguns are clearly protected under the Second Amendment. That's what Heller said. Although they haven't officially ruled on rifles or shotguns yet, it seems pretty clear that they're going to be, based on the Supreme Court precedent and the criteria and how the lower courts are starting to apply that. So why wouldn't short barrel rifles be also commonly possessed by Americans and therefore protected under the Second Amendment. What gives with all of this? In other words, I guess what they're saying is if these pistols become deemed short barrel rifles, will there be a constitutional argument that, they're commonly possessed by Americans for lawful purposes? How many pistol braces have been used in murders in the history of America? I'm guessing not that many, if any. So how would that constitutional issue play out, Stephen?
Okay, so Heller, District of Columbia versus Heller, held that the kinds of arms that are commonly possessed by law-abiding people for lawful purposes, or that are typically possessed by such people for those purposes, are protected by the Second Amendment, which of course protects the right of the people to keep and bear arms. For two reasons, an argument could be made that SBRs are commonly possessed by law-abiding people for lawful purposes. First of all, there's hundreds of thousands of them actually registered with the ATF. $200 doesn't mean today what it meant in 1934. It's no longer a prohibitive tax on behalf of people who want to possess these kinds of rifles. But if ATF extends that and says that pistols with braces are short barrel rifles, that's going to bring in hundreds of thousands of more firearms that are commonly possessed by law-abiding people for lawful purposes. So there certainly are going to be Second Amendment arguments that could be made in the court system on behalf of Second Amendment protection for these types of firearms, and then that raises the question of is it constitutional to tax and require registration of arms that are protected by the Second Amendment?
Steve, what's going to happen if this regulation goes into effect? And again, we don't even know. I mean, we're sort of debating hypothetically here, because is it still possible that the regulation will not go in effect? Is it still possible the ATF could even pull the regulation? I believe they've done that in the past, where they propose something, then they pull it.
Yeah, very infrequently they will pass something. They've been instructed by the Biden administration to do this. You've got political forces, the administration, certain members of Congress, the anti-gun lobby groups, and this is one of their agendas. What they do is, okay, pistols with braces, they're not widely used in crime, but why don't we chip away and try to ban or make it hard to own different types of firearms if we can't ban them all? And so that's what's going on here. They will pass restrictions. They will try to redefine rifle to extend that definition to include more than what Congress has passed.
So, Stephen, what's going to happen with those people that live in states like, I don't know, Rhode Island, New York, the usual suspect states where, short barrel rifles or whatever are banned? What's going to play out for the people that own these lawful handguns that also have pistol braces? What are they going to do? Are they going to, will it make a difference if they remove the pistol brace from these guns? Or does that even matter? What happens? So if I have a pistol with a brace and I just remove the brace and just throw it away, do I now have a handgun, or is that still an SBR? Or how will that play out, especially in these states that ban short barrel rifles?
Right. So currently, I'm not aware that any of these states, well, I shouldn't say I'm not aware. There could be states now that ban pistols with braces, but I don't know who they are. It would be the usual suspect states if that exists. But so if ATF requires them to be registered and says they're SBRs, short barrel rifles, well, that's the federal government saying that. That doesn't necessarily mean that the states with rifle bans, short barrel rifle bans, will follow, but they most likely will defer to ATF. And so the owners of these are going to have to make decisions. Do you throw away the brace, just get rid of it altogether? I mean, it's going to be the same thing if ATF classifies these pistols with braces as short barrel rifles. Are they going to require them to be registered under the NFA? Are they going to require the $200 tax to be paid? And can they do that? I mean, there's going to be all kinds of litigation challenging ATF if they try to say these are NFA firearms and you have to register them, and if you don't register them, you're subject to 10 years incarceration. That's not the way it works. That's not the way criminal law works. So to get into compliance, you'd have to pay the tax. But if you're in a state that bans short barrel rifles, you have to just get rid of the firearm, or at least get rid of the brace.
Stephen, one last question on this topic. So, Stephen, what is the story with this amnesty, this notion of amnesty as applied to these stabilizing pistol braces? What exactly is amnesty mean? Has it ever occurred before? How does all this play out in the context of this regulation that we suspect will be coming out sometime late fall, maybe December-ish? We don't know. But what does this talk about amnesty for people, and what does all that mean in terms of whether or not they're going to be going to jail or need to get rid of these stabilizing braces on their pistols?
Well, in 1968, Congress redefined NFA firearms to include items that were not there before, including destructive devices, expanded definition of rifle, shotgun, a machine gun. And so they declared an amnesty. The ATF was authorized to declare an amnesty so that people could register these newly defined NFA firearms. And if you read that statute from 1968 carefully, ATF retains the ability to declare an amnesty, and it could allow the registration of items as NFA firearms without a tax. There's even a provision in the Internal Revenue Code, and don't forget the NFA is part of the Internal Revenue Code, that authorizes a non-retroactive status to be declared. Originally it was by the Secretary of the Treasury, now it would be by the Attorney General. So you could say that certain items, and ATF did this for other items that it said were semi-autos and later said were machine guns, that if they were made before a certain date, they're semi-autos, and if they were made after that date, they were machine guns. And so there is some flexibility here, but I don't expect ATF to do any of this. I think they're most likely to adopt some regulation, because that's what Joe Biden has told them to do, and they're going to include items that are now considered pistols with braces, and they're going to make them into short barrel rifles.
Well, there's a lot going on with this pistol brace issue. We're going to just have to follow this carefully, but there's a lot of speculation out there. I'm not sure how much we should credit it, but we should pay attention to the facts and make sure we get this right, because this is a really important issue, especially if you get this wrong after this new regulation. You could possibly go to jail for years for a malum prohibitum victimless crime, which would be terrible. But again, I agree with you. This administration has a lot of political pressure to do things that are bad to gun owners, and this is just the most recent one. So, Stephen Halbrook, thanks for talking to us about pistol braces.
My pleasure, Mark. Thank you for having me.
Okay, folks, I hope you learned something here at the Four Boxes Diner from Stephen Halbrook during that interview. I certainly learned a lot. Again, if you haven't subscribed, please do so. And again, we'll see you again next time here at the Four Boxes Diner.
Orders up. Table 2A.